Well, good morning, good afternoon, good evening if you're watching this later. um, it is the Wednesday webinar series from the B.R.I.G.E Project. So, the B.R.I.G.E Project is an acronym. B.R.I.G.E stands for Bridging Resources into Diverse Groups Everywhere. Our goal with the Wednesday webinar series was to reach parents of individuals with disabilities, the individuals with disabilities themselves, and just provide support for our parents that we used to meet in person with. And this is just a time for you to ask questions, to learn about resources available, to learn about other organizations and the amazing work that they're doing. This morning, we're happy to have back with us Matthew Hoeg from CSA San Diego County. We've had him here pretty early on in the webinar series. I believe he was our first presenter. So we're happy to have it come back around and he's back to share some new information with us. As I said just before the top of the hour, I will be sharing some links. A lot of parents have been giving me a call asking me about HUD housing. Is the county still doing rental assistance for upcoming and past due rent? There is a new link that I just got with regard to security deposit assistance. So I will definitely be posting those in the chat. Just want to give a little bit of information about CSA San Diego County. I won't read the whole about me section, but I will just share some highlights. Just really quick because I still see we have people coming in, but let me go on and do that. So there are eviction protections that have been put in place that are part of housing laws. There are protected classes, saying a lot of like buzzwords, and there's the Fair Housing Act, FHA. A lot of people know about FHA loans. But if you're wondering exactly what the Fair Housing Act is, this is just a little bit of what we're going to learn about today. CSA San Diego County is a 501c3 nonprofit organization. Their primary mission is the promotion of social justice and public welfare through programs, services, and advocacy against all forms of discrimination, including advocacy for the eradication of housing discrimination, and that's to assure equal housing opportunity for all individuals. And CSA is committed to promoting and enforcing those laws and opportunities for individuals who live in San Diego County. Their cost is a no-cost service. They also have hate crime prevention services, civic engagement, human trafficking prevention and education. He's going to share more with us. If we can do what we always do right when we're introducing our guest, our feature for the morning, if we could just do a COVID clap. Those of you who are behind your initials, I just trust and believe that you're doing this as well because you guys know the drill. It's been a year, okay? So this hand doesn't touch this hand. This is the pandemic COVID clap to welcome Matthew Hoeg from CSA San Diego County. Welcome, Matthew. Good morning.
Good morning. Thank you so much, Melissa, for the invitation to be here. It's always a pleasure, and always a pleasure working with you and Better Life Together and the B.R.I.G.E Project. You all are certainly doing great work yourselves. So we're glad to collaborate in this capacity. I think you broke down pretty well what CSA San Diego County does. Like Melissa said, we're a nonprofit, we're grant funded, so all of our services are free. And we really strive our main goal is to eradicate discrimination in San Diego County. That's really what we're working towards. With that, we do have a lot of housing counseling that we provide with our HUD approved counselors. and they can help with tenant landlord issues as well as if you're seeking to buy a home, they can also help with that process as well, and kind of navigating the finances, the mortgage, the brokers, all of those little tiny aspects that go into the lengthy process of buying a home. So with that, there are a number of things that I wanted to go over today, but Melissa, if I can ask you just to keep me in the loop on time, just to make sure I don't overdo it. I could talk about fair housing all day, but got to make sure I'm on track. So with that, please put in questions into the chat. I figured today I would talk about really the Fair Housing Act, specifically as it relates to disability and family discrimination. We'll talk about kind of what the Fair Housing Act encompasses, but I figured today we'd focus on those two protected classes, and then also talk about the rental protections that Melissa was alluding to earlier. So a lot to discuss today, but certainly want this to be a conversation as well. So please put in any questions in the chat, and we'll go from there. But again, my name is Matthew, and I was actually in Des Moines, Iowa for a couple of years investigating housing discrimination complaints, and recently moved to San Diego and have been acting as the outreach and education coordinator for CSA for the last year or so. With that, it's always exciting to be able to share knowledge to others so that they can kind of assert their rights and make sure that they're able to enjoy their housing to the best capacity, because housing is the primary focus of all of our lives. So we'll start off talking about the Fair Housing Act. Essentially, it protects people from discrimination when they're renting or buying a home, getting a mortgage, seeking housing assistance, or any other housing related activity. So right after the assassination of Martin Luther King, the riots and protesting that took place really pushed for this act, which was actually already written to get to the Senate floor. It was pretty resistant by legislators to get it to a vote, but because of the protests and movements that took place, they were able to get the Fair Housing Act to the Senate floor and pass. So knowing that history, it's really important that we think about how we're enforcing this act, letting people know about it, and what their rights are, so we can make sure that people are able to worry about their lives rather than their housing. And that's really the goal. So we have these 7 protected classes here that are listed under the Federal Fair Housing Act. There are some additional protections under California, but essentially the Fair Housing Act ensures that people are not being discriminated against on the basis of disability, race, color, national origin, sex, familial status, and religion. In the state of California, there are additional protections, including immigration status, sexual orientation, sexuality or gender expression, identity, inclusive of veteran status, as well as source of income, which is another important one right now, because a lot of people are receiving Section 8 or rental assistance, et cetera, and we need to make sure that landlords are willing to accept those finances. So with that, we'll jump into disability, thinking through how the law protects individuals with disabilities when it comes to housing, and then we'll talk about reasonable accommodations and modifications, what that means, to really dig into those protections. But essentially, it's unlawful for any person to refuse to make those accommodations in their rules or policies when those accommodations may be necessary to afford someone with a disability equal opportunity to use and enjoy a dwelling unit. And I want to take this moment to say that the law uses the word handicap. Obviously, that's an outdated term, but that's what's listed in the law. So we understand that to mean a person with a disability. But essentially, this applies to any aspect of housing, including the public and common use areas, and it's also unlawful for a person to refuse to permit, at the expense of a disabled person, the reasonable modifications of the existing premises. So if somebody needs a handlebar in the bathroom, those types of things, those would be considered modifications. And we'll dig into that a little bit more. But essentially, the Fair Housing Act asserts that individuals with disabilities have the right to request these accommodations or modifications so that they can enjoy the property to the same extent as anybody else living on that property. So we also have the Rehabilitation Act of 1973, which indicates that no qualified individual with disability should be excluded from participating in, be denied the benefits, or subjected to discrimination under any program or activity that receives federal assistance. So the main example of this is Section 8, or I'm sorry, HUD Approved Housing. So when HUD is offering housing to individuals, there are specific requirements that they have to adhere to make sure that individuals with disabilities are receiving the same treatment. So we also have the Americans with Disabilities Act, and Title II of the ADA is prohibiting discrimination in all programs and services and activities made available by public entities. This includes housing provided or made available by the government. So really indicative that there are some additional requirements that housing provided by the government has to adhere to. So Title III prohibits private entities that own, lease, or operate places of public accommodation from discriminating on the basis of disability, and requires places of public accommodation and commercial facilities to be designed and constructed and altered in compliance with the established accessibility standards. So again, really important that even as we think about rental offices and apartments, that as they're built, that they're keeping in mind these accessibility standards, making sure that people with different mobility devices, different disabilities are able to enter into that facility and access those services. So we can talk about what counts as a disability. It's really thinking about any physical or mental impairment that substantially limits one or more major life activity. If they have a record of such impairment, or being regarded as having such an impairment, right? Somebody in a wheelchair is clearly a person with a disability, and therefore can be regarded as having an impairment. The law also includes those recovering from alcohol or drug addiction, and really considers that to be a disability where they can request certain accommodations to make sure that they can continue their treatment, etc. So all of these in mind, anything that really inhibits a major life activity, whether that's seeing, hearing, walking, breathing, performing manual tasks, being able to take care of oneself, learning and speaking, all of these aspects are considered major life activities. And if someone has a disability that's impairing one of those particular tasks, they can assert the law in this particular regard to make sure that they can have access to equal housing opportunity. Some examples might be visual or speech impairments, hearing impairments, spinal bifida, muscular dystrophy, multiple sclerosis, pregnancy, some mental disabilities as well, bipolar disorder, depression. We also consider HIV, diabetes, heart disease, cancer to all be encompassing of disabilities. There's also talk about long COVID and post-COVID to be considered a disability under this, so long as it can be demonstratable to inhibit a particular life activity long after diagnosis. So what are the two kind of main facets of the protected class of disability? We talk about reasonable modifications and accommodations. So we'll start with modifications and then jump into accommodations. But essentially modifications must be allowed. And this is referring to any necessary physical changes to the property, covering a private living space or common areas, right? So if the doors are too narrow, the person can request, look, I need the doors to be widened so that my wheelchair can move through the space. So essentially they're necessary to afford a disabled person the full use and enjoyment of the property. They have to be reasonable. So for example, if somebody needs access, they have a second floor apartment, but then develop a spinal injury that inhibits their ability to walk up the stairs. They, instead of requesting perhaps an elevator, which because it's an expensive feature that needs to be put in, the landlord might say, well, what if I open up a first floor unit? right? So that shift in the conversation to become more reasonable for to allow that person the necessary adjustments, but also to allow the property to be able to afford what they can and ensure that that reasonable level is met. Anybody making a request for reasonable modification, they can't be evicted just for making that request. Instead, they would engage in a conversation, and they can't be retaliated against for asserting their rights in any way. Generally, modifications are at the resident's expense. For example, if they put in bars in the bathroom for stability, the resident is generally the one that's going to pay for that. And then the landlord can say, okay, once you move out, we'll need this to return to its normal state. But generally, people keep them in place for the benefit of other tenants that move in. Additionally, the Federal Housing Act allows a separate security deposit to restore the property back, but it can't exceed the cost of the restoration, and it must accrue interest. Now the kind of narrow caveat here is that if the housing is provided by a governmental entity, the governmental entity may be required to pay for that reasonable modification. So there are some exceptions, but essentially requesting a reasonable modification to take place is the right of an individual or resident to really utilize. So thinking about accommodations, this is really a change to the rule, policy, and procedure that's going to afford that person the full use and enjoyment of the property. Exemptions from resident rules and policies and practices or services. And then this again can include their private living space or the common area. So it's not reasonable if it imposes an undue financial or administrative burden on the housing provider, but they're still required to engage in that conversation of how best to, provide these services to the tenant. So an example is allowing a service animal into the unit even if there's a no pet policy, or allowing the person to get a parking spot that's closer to their unit because of their disability. Those are kind of changes to the regularity of policies to make sure that that person is enjoying the full benefit of the property. And they can't, again, be evicted for making the request. And again, at this juncture, the housing provider is the one that's responsible for any costs associated with the reasonable accommodation, unless it's an undue financial burden. I had a tenant simply requesting an extra key to give to her neighbor to check in on her because she had epilepsy and wanted to make sure that she would be able to, if something were to happen, the neighbor would be able to come in and check on her to make sure that she was okay. So the landlord decided that they did not want to give her an extra key under the guise that it was an undue burden. But it's literally $3 to go make a key at Lowe's. So that's really not a sufficient answer for an undue burden to go spend $3 at Lowe's. So thinking about those kind of administrative burdens really becomes something to keep in mind, that if an accommodation is requested and they come back and say it's an undue burden and you don't think it is, that's the time to potentially have a conversation and really see, okay, is this really a difficult financial burden to go spend $3 to get that extra key for this person. The landlord provider can verify if a disability exists. The landlord does have that right. So they can ask the tenant for verification of a disability related need for the accommodation or modification. However, and this is really what's important, is that the housing provider is not entitled to know what the disability is, the identification of that disability or diagnosis. All that they need to know is that the person that a disability exists for this person, and that diagnosis is related to their need for the accommodation. So for example, if somebody is having some type of nervous issue, nerve disorder, right, that's functioning, inhibiting their ability to maneuver well, they may ask for that first floor apartment, but the landlord wouldn't have to know specifically what that nerve disorder is, but just that a disability exists that inhibits their ability to maneuver stairs. So really thinking about the basics of what the landlord needs to know, that a disability exists and that it's related to their request for an accommodation. They can request that information, but they don't need to know what the disability is. All right, see if my slides are moving here. So these are just some examples of some reasonable accommodations. We get a lot of people who are on Social Security and requesting a change of the date as to when rent is due, because their Social Security check comes in a couple days after the first of the month. So they're saying, oh, let me pay rent on the 5th rather than on the 1st of the month. We're seeing a lot of, during COVID, a lot of requests to kind of an extra 30 days to search for a new apartment, because it is a difficult transition for them, to make sure that they are avoiding any contamination with COVID, really making sure that they're safe with the pandemic. So extending a resident's move-out date is an accommodation that's required. Residing in a smoke-free environment, also an example of one of those accommodations. Giving a resident an opportunity to correct minor lease violations. We see this with children with autism oftentimes. They're kind of functioning, excuse me, the rules are functioning in a way that inhibits children with autism in a particular way. So the tenant has the right to ask, okay, this is a minor lease violation. My child has a disability. How can we navigate this? And really requesting that kind of change to the policy is going to be the accommodation. And we'll talk about families as well here in a minute. But really it's important to think about what types of accommodations can help to make sure that the tenant is allowed to live in the property to the full extent. We talked about kind of a different parking space, making certain repairs to accommodate a resident. We're also seeing a request to delay repairs, right? So if it's a minor repair, like say the blinds are just a little bit funky and wonky, they can say, look, I know this needs to be fixed. I'm putting in the request, but I haven't been vaccinated yet. Please wait until I'm vaccinated for you to come in and fix this, so that I can ensure my safety if I'm immunocompromised, whatever that might mean. Allowing a tenant to have a co-signer. Again, allowing to move to a first floor unit. So really, when we talk about reasonable accommodations, there's quite a bit of variability in what that might look like, and it depends on each person and their disability. But essentially, they can engage in a conversation with the property manager to say, look, this is my disability and what I'm limited by and what I need. And then they can engage in that conversation. All right. So essentially what we're looking for when we're looking at discriminatory cases is really just to refuse to rent to somebody. And that can come under the guise of a stigma or a liability. And this can come in phrasing such as, I do not rent to people with mental illness because they are unstable and not responsible. So that's going to be something that really inhibits a person to live where they can afford to and want to live, solely on the basis of their disability. And that's really the cookie cutter symptom of discriminatory action. Refusal to allow accommodations or modifications. And so an example of this is we have a strict no pets policy, and I cannot allow you to live here with your service animal, because then all the other tenants will want an animal. So these are quotes that we've heard from landlords that are demonstrating their refusal to engage in an interactive process to find out what that accommodation might look like. We also see eviction due to requesting an accommodation or modification. And it sounds very explicit, but it sometimes becomes very subtle in how it's phrased, such as, you will have to move because I can't allow you to modify your unit to have an accessible bathroom or kitchen. We've also heard phrases such as, this may not be the best place for you. Maybe you should find some place that's better accommodating for you. Those types of phrasings are really going to be indicative of potential discriminatory action. Building properties that are not accessible. So might be a 30-unit building with multiple floors and an elevator built in 2019. So that would be required to comply with the 7 design and construction requirements that allow accessibility with, for individuals with disabilities. So really important to think about how the construction of a property is built so that individuals with disabilities can maneuver it. And I'm a big advocate. I think we need a lot of individuals with disabilities designing buildings and really thinking about that accommodation. I was just at SDSU campus yesterday and saw that there was a ramp weaving through a garden area and really integrating the pathways into the actual structure of where we're moving through our lives. So really important that we're thinking in that mindset, especially when it comes to our housing. All right, so with that, I want to shift a little bit to familial status. And I think that we can kind of see the conjoining of disability with familial status in terms of the ways discrimination occurs. And so really thinking about how these two might conjoin in a lot of different ways. But familial status is really defined as anyone, any resident with individuals under the age of 18 present. So it's really important to think about the different ways that families are configured. It may be a parent with their child, it may be an aunt or uncle with their child, a grandparent, or even an adoption process or fostering process. But essentially all that's required for familial status is somebody in the house that's under the age of 18. This also includes women who become pregnant. Sometimes we find that a landlord learns that a woman is pregnant and then starts to treat them very differently. So that's going to kind of fall under familial status and even sex protection. But essentially we see some of the same things here. A housing provider, such as a landlord, cannot refuse to rent to an applicant because they have children in the family. This could occur even if the child has a disability and the landlord says, no, we can't accommodate you. That's going to be a discriminatory case that we're going to look at. The requirements for rental terms and conditions has to be the same for families with children as the other applicant. Sometimes there are exceptions for age-specific housing for senior citizens. So there are specific rules for housing that they've submitted paperwork and are specifying themselves as housing for persons 55 and older or 62 and older. So there are some exceptions there to kind of take a look at. But to qualify for senior housing, housing accommodation must meet specific legally defined requirements that include minimum number of units, age-based residency limits, etc. So essentially, unless you're in one of these older, unless you're in one of these age-specific complexes, the familial status application is going to apply. So some of the examples that we've seen when it comes to terms and conditions is we've seen more restrictive rental criteria where they may say, well, you have 3 children, so we're going to increase that deposit amount because we don't know what the children are going to do. Adult living, calling it adult living, using that phrasing, saying that there's an adult-only pool. Those types of things are really going to kind of raise some flags in terms of what's going on. Paying an extra deposit because of extra wear and tear for having children, etc. So we often see rules as kind of the point of contention when it comes to familial status discrimination. So they might put in rules that say children must be accompanied by a parent at all times. They start implementing some curfews. Saying you have to stay indoors, children have to stay indoors and are only allowed in a certain designated part of the complex, that you can't play outdoors or require only activities that limit all noise. So these are kind of rules that are specific to children when in reality all you're concerned about is the noise. So rather than applying rules to all residents, you're coming up with rules that specifically apply to children. Some other examples are that children may only enter the pool if a parent is present, rather than the safety issue being that with somebody who's older than a particular age with them in the pool for safety reasons. So really starting to distinguish, is this specific to children or for safety, is really where sometimes those point of contentions arise. restricting children from disposing of the trash or checking the mail, or no children allowed under 3. Anything that says no children is certainly going to raise a flag, right? No kids, etc. So we see this oftentimes more often enforced with children with disabilities, and that's something to keep an eye on as well. That sometimes with children, with families who have children with disabilities, these rules start to kind of come up more and more often. So we definitely want to keep an eye on that, and if they are coming up, take a look. All right, occupancy standards. This is another kind of point of contention that landlords use to discriminate against families with children and individuals with disabilities. So we see that there are specific age and gender restrictions. So they're saying occupancy standards can't exceed 1 person per room, or restrictions regarding the makeup of the household, or the number of children allowed. The general rule of occupancy, and again, it's not kind of a legal definition, but people generally go off of 2 people per room plus 1. So if it's a 1-bedroom, kind of thinking around 3 people. If it's a 2-bedroom, you can generally think around 5. Now, if there's a house that has, say, 2,000 square feet, but it's only got 3 bedrooms, that house could probably accommodate quite a few more people. So really thinking about the spatial layout as well is something to think about with these occupancy standards. But essentially, we see landlords will say, oh, we have certain occupancy standards that prohibit you from having your children in this place. So it becomes a way for them to discriminate against families with children. Additionally, we have a number of cases of individuals with disabilities who need an extra room for their equipment and that extra space. So they're requesting to be able to stay in that extra space, despite some of the kind of policies in place for Section 8 say that, you know, because you're 1 person, you have this amount of space. But because of their disability, they need extra room for their equipment. So we're just requesting that they can have that extra room to make sure that they can have their equipment with them in their home. So sometimes liability claims come up. We don't want to rent to children because there's no fence around the pool, or our complex is not gated and near busy roads, so we cannot allow children. We sometimes see steering happen where they're saying families with children must live on the 1st floor or in a certain part of the complex due to noise complaints. These are all things that are indicative that they're treating families with children differently than other tenants. Like I said, there's oftentimes a lot of contention around some of these rules. And when that happens, sometimes harassment occurs, where a landlord starts confiscating toys or bikes or certain items from a child as punishment. They might yell at children and reprimand them rather than discuss with the adult responsible, or threaten to call child protection services for unjustified reasons. They might also start serving notices trying to terminate that family for alleged violations of unreasonable discriminatory rules. So all these things to kind of keep an eye out for. And in terms of familial discrimination, I wanted to talk a little bit about what happens when one of these issues comes up, right? Whether it's with disability or familial discrimination, or even with race, gender, sexuality, all of those different protected classes. If there's some type of red flag, you know, letting CSA San Diego County know, we can take a look and see what's going on and what those next steps might look like. And so generally what happens once the discrimination complaint is kind of brought forward is that we can have a mediation take place. And a mediation doesn't necessarily mean that both individuals sit in the same room and kind of talk through things. We start to come up with kind of ways that they would be able to move forward from the situation. So we'll do kind of the back and forth of, okay, you know, the resident, what's going on? What do you need? The landlord, okay, what can you do? And really kind of facilitating that interactive process of how to move forward. If the landlord is not willing to engage in that process and it's looking to be more discriminatory in the explicit nature, we might be able to file an administrative complaint with Housing and Urban Development or the Department of Fair Employment and Housing. And so what they would do is they would conduct a full-on investigation, do some interviews, evidence gathering to see if the law would support a discriminatory lawsuit. And if so, they try and conciliate and mediate at that point. If that fails, then it would move forward into a court dispute and really go through the court process. So with that, we obviously hope that we can mediate the situation, have the landlord put in new policies, retract any rules, allow that person to find housing, really kind of understand the law and then change their actions for future use right away. So that way that individual can just keep going on with their housing and enjoy it to the full benefit. If they're continually being denied or treated differently, it can be a lengthy process to move through the court system. But oftentimes what I've found is people moving through that system, the reason they're doing it is not just so they can become compensated in particular ways, but so that the policies will change so that this doesn't happen to anybody else, and really avoiding discrimination in the future. So those are kind of the ways to resolve a discrimination complaint. In terms of those court mediations, sometimes injunctive relief is offered, monetary or compensatory damages, which might include out-of-pocket expenses, emotional distresses, and attorney's court fees and costs. Now, when somebody brings forward a complaint, again, all of CSA's services are free. When you file a complaint, that's going to be a free process provided by the state or federal government. And then if they find that discrimination did occur, the government would move forward in that court case. So those attorney fees and court costs are actually governmental costs that they pay, and then the compensation might just reimburse the government for that. So it's not necessarily that a person being discriminated against would have to pay any attorney fees. I just wanted to clarify that bringing forward a complaint is anybody's right, and it's a free right, that you don't have to spend any money or have money to really assert that right. So here's our information, and you can give us a call, and one of our counselors will talk with you about what's going on and figure out those next steps. And I always like to say, if something feels off in the housing, give us a call. We'll talk through. And if we don't know the answer, or it's not necessarily a fair housing issue, we'll try and get you handed off to a resource that can help you navigate that particular situation. So when in doubt, just give us a call anyway. This is our website and information. And I'll put my information in the chat as well. I am going to jump into talking a little bit about the emergency rental protections, but certainly if there are any questions about some of those fair housing issues, please put it in the chat or let me know. Now might be a good time to kind of talk through any of those before jumping onto the emergency rental protection.
So good morning again, everyone. I know we had a few more folks that came in just a little bit after we began. Feel free to add your questions to the chat. I've also added my contact information. Matthew's going to add his contact information, and the CSA San Diego County web address, so you will have that. And then there was also a link for security deposit assistance that I added. And if you'll bear with me before we wrap today, I will add the information for the Urban League for home buyer assistance. I just want to ask, I know CSA has been a huge assistance to and a resource to a lot of families that we work with this past year for the B.R.I.G.E project. I know several folks, including myself, attended the HUD home buying certification program. Along with that, it's just not, sitting on a webinar. There's actually, and he touched on this previously, you also get assistance with just creating a budget. Sometimes that's foreign to a lot of folks. just to understand, what does that actually look like? What does that actually mean? I know how much I got, you know, and I know how much I got to pay in bills, but actually creating a budget
Mhm.
is sometimes a challenge for folks, and it used to be for me as well. So I am a lot like all of you on here. I'm a parent. I'm a parent of an individual with a disability. I'm a parent of a teen. Well, actually, two teen boys, and this is a lot of what we need to know. And some it's just that little wording. Matthew mentioned no child or no children. That just immediately should send off signals, and that's something that I have seen. I've seen signage like that. But if we don't have any questions as of yet, I'm going to go on and mute and pass the Zoom mic back to Matthew.
Okay. All right. Yeah. Please feel free to put into the chat if you kind of think of a question later on. I can always go back as well. But in terms of the financial budgeting, yeah, our counselors are really knowledgeable about the process of getting those finances in order to buy a home. And Melissa, you brought up a good point in terms of thinking about, yeah, we might know how to kind of maneuver finances, but preparing to buy a house is a very different financial literacy than even just paying those bills, right? And we often think about different socioeconomic classes, and how to pay bills is very different. It's a different mindset when you don't have a lot of money to when you start to accumulate money to start thinking about buying a home. That you kind of rotate bills and so forth, and making sure that you're keeping the lights on, very critical aspect. So that shift through kind of the financial realm is definitely something we can help with. I know our counselors also have a lot of expertise in terms of credit scores as well. So making sure that credit score is going to be prepared for the arduous process of going through the bank loan process. So all of those little intricate aspects that are involved, our counselors can help you out with. So if you're not even sure where to start, give a counselor a call, and they can just start asking the questions to kind of get your mind moving in the right direction. But certainly a lot of questions that go with that. So feel free to check in. With that, we'll talk about the emergency rental protections that are in place. Melissa, I'm glad to hear that they're offering the security deposit assistance now. Certainly always a benefit, especially as we're seeing a lot of people are increasing security deposits amidst the pandemic. And they're even doing that kind of as a retroactive maneuver. So certainly something to keep an eye out for moving forward. But things have constantly been changing with these emergency rental protections. Currently, the Senate Bill 91 has been extended through the end of this month, and that's at the state level. There are some local measures which kind of look at the rental assistance programming. And then on the federal level, it was based on transmission status of COVID as to whether or not eviction protections would apply. I think a court knocked that down earlier. So it's been back and forth on the federal level, unfortunately. But luckily here in the state of California, they've extended those protections at least through the end of this month. So this is kind of the timeline that's been set up. Essentially, most of this was kind of really put into action at the end of February. Although there were protections before that, this was when this particular form of the protections took place. But basically what it was saying is that the landlord had to provide notice to the tenant of what is owed. And then starting in March, tenants could apply for the emergency rental assistance programming. And then by the end of this month, tenants should pay at least 25% of their rent. So that could have been either monthly, or they're going to need to pay a lump sum before the end of this month of their rent for the last year. As of October 1st, landlords can start pursuing those rents as a civil debt. So essentially what that means is that if there's still money owed on that rent but you've paid the 25%, the landlord can pursue that date through civil court, but can't move to evict you for non-payment of that rent for the last year. That being said, starting October 1st, if you don't pay your rent, they can move to move forward in a regular manner, assuming no further bills are passed on this front. There have been various extensions. The caveat here is that the reason for not paying rent has to be because of a COVID-19 financial distress, and you're signing a declaration under penalty of perjury that it was because of reduced income or increased expenses, caring for a family member, etc. Some type of situation because of the pandemic that really inhibits your ability to pay the rent obligations. The landlord has obligations to provide you with the declaration, and it has to be in the same language that your lease was negotiated in. So if your lease was negotiated in Creole or Spanish or Tagalog, whatever, or Arabic, then that form has to be in that particular language as well. Late fees can't be assessed if that declaration is submitted. And then rather than a 3-day notice, they're having to provide a 15-day notice for that response time. So the amendments kind of exclude eviction proceedings for any other reason that's not related to COVID-19. There are some kind of local exemptions. I know there's some exemptions in San Diego that kind of prohibit different forms of evictions as well. So it's going to depend on the locality, but really thinking through, okay, if an eviction is kind of moved forward, what does that mean, and how is that being processed? If a landlord moves forward despite someone filling out that paperwork, there's penalties in place. And then the public disclosure of an eviction, if it does occur involving non-payment, is going to be restricted from public view for a time. So in lieu of all this, the kind of the complementary piece here is the rental assistance programming. So the federal funds are available through the ERAP program to assist in paying owed rent. I'm not sure if there are updates on future rent, to be honest. So, but that's something I can look into if there are questions on. I know their focus has been on past rent, and they're prioritizing lower income tenants. So really trying to ensure that those who are having more difficult time paying their rent are prioritized. They moved it to pay from up to 80% to now pay up to 100% of the past due rents. There are some restrictions in terms of the full amount that they can pay. I think there's a monthly allotment of how many months of rent they can pay, but it's going to depend on kind of each individual situation that they're going to look at. So in some situations, it could be up to the 100% of past rent, but again, it's going to be dependent on a number of different questions. So notice of rent owed must be given to the tenant from the landlord with information about rental assistance programming. So if you receive kind of that, you haven't paid rent, but you're not receiving the rental protections notice, the declaration form, and the ERAP programming, there's going to be a question there as to why you're receiving that without the additional paperwork. So really important that all of that paperwork is provided by the landlord. It's important to remember that the rent is not forgiven. The obligation still exists. And that's really one of the key things that we've been trying to emphasize, that even if these protections are in place when somebody can't pay rent, that rent is still owed. The question is, how does it get paid? And so that's really how all these things are coming together. So a really good resource here is housingiskey.com. That's the state resource on these eviction protections. It's been staying up to date with most of the information. The emergency rental assistance program is going to depend on where you're at. So again, these are the federal funds. There might be some additional programming that's providing their own funding. There might also be some programming through different nonprofits that are facilitating the payment of this information. So for example, in Chula Vista, I know South Bay Community Center is facilitating some of the payment of the rental assistance funds. So but essentially, if you're in Chula Vista looking for rental assistance, you just go to chulavistaerap.com and apply through there. In San Diego, they have their own program through the San Diego Housing Commission. And then anywhere else in the county is going to go through erapsandiego.org. So those are really the sites to go to help pay for rent. I will send out our fact sheet that we've written out, kind of outlining the eviction protections in conjunction with the fair housing laws, what we've been seeing in terms of kind of heightened issues during the pandemic, et cetera. So I'll send that link out as well. But essentially, our COVID-19 resource page has been updated pretty consistently with the information that we're getting and trying to stay up to date with all of this. So with that, I'll kind of leave it to questions and we'll go from there.
It looks like we do have one. It says, I requested an extension with Section 8 recertification due to disability, son's disabilities, surgery and recovery time, mental depression affected severely due to COVID-19, including financially, and was denied and wasn't told not eligible. Regional Center helped and have email stating they have paperwork, but haven't heard anything from anyone, no response from Housing Authority by phone or email, and they haven't paid their portion. What, if anything, can be done?
That's thanks for sharing your situation there, Claudia. And I think that we've been seeing a lot of questions surrounding individuals with Section 8, especially with disabilities. So I don't know kind of what the specifics are of that, but certainly there can be questions raised as to whether or not the denial was sufficient, in terms of really asking Section 8 why that denial was put into place, and whether or not that's a justified reason. So you can certainly give one of our counselors a call and they can see if there is kind of some discriminatory questions there. And if there are, potentially some kind of remedies as far as kind of why they haven't paid their portion. I'm not quite sure, but certainly some questions are raised, right? And that would be the point to kind of check in and see from the housing authority what's going on, if there's any justifiable reason for their actions, or whatever reasons they're providing, are they sufficient? Really starting to ask that question. So our counselors can certainly take a look at that, move forward in kind of presenting those questions. And then if there isn't enough justification, we can also move forward in kind of potentially filing a complaint or asserting some pressure to mediate that situation.
And I did just add a screenshot of the slide with CSA's information Matthew shared a bit ago. So that is in there, and also his contact information is there. It looks like we have a comment. Nasir says, thank you, Matthew, for the valuable presentation on fair housing and COVID-19 rental assistance. This is great. I'm appreciative as well. All right, looks like we've got the contact information screen up again. If you all need to take a screenshot or write that down, yay. And just want to reiterate, if you are the parent of an individual with a disability or the individual with a disability themselves, please feel free to reach out. My contact information is in the chat as well. If I do not have an answer, Matthew can attest to this. I will loop him into an email in a hot minute. I will do that very, very quickly. We also do have some partner resources for grocery assistance, art classes, music classes. We have a partner. She's actually coming back around as well. There's a parent training for IEPs, and you can get that paid for and covered through San Diego Regional Center. You just ask me how. We'll be just resharing, because I don't think it hurts to do a refresher on exactly what the Bridge Project does and how we serve individuals in San Diego County. So please be on the lookout for that. You can always follow our events page or our social media. Just search A Better Life Together. It's not spelled differently at all. Um, you will get copies of the slides. I always add the slides up above the video on the video replay page. And so you can just click and download the slides, and that'll be on Friday. Those will be available at the latest. I always say Friday afternoon, but I always try to get it up before. If anything strange happens, like a pandemic, then it could be Monday.
Oh wait, we're already there.
I had to.
Yeah, no, you got till Monday.
You're welcome, Claudia. You're welcome, Mina. Thanks again to everyone. If there's any other questions, y'all feel free, type them in. But otherwise, and I know that you all are doing this, even though, we don't bite. We're family now. We've been doing this for a year, you all. Y'all can come on camera. But we're going to officially thank Matthew Hoeg and CSA San Diego County for being with us. We're just going to do that pandemic clap one more time. This hand can't touch this hand because we don't know what's going on with it. Thank you so much, Matthew, for coming back and sharing these amazing updates. Went on and shared a shot of the screen right now to our Facebook page, so you can grab that if you need that slide immediately. Again, I've also shared it in the chat. You can just click and download it. And then I'm constantly tagging CSA in posts that I'm resharing, or things that I see, events that they're having. But yes, highly, highly recommend talking to the housing counselors, getting your budget together. Just being ready and getting ahead of it when you're looking to purchase a house. They're an excellent resource. They really kind of demystified the process for myself and my sibling, and quite a few parents that we work with. So very grateful for CSA San Diego County. But y'all have a blessed rest of the day. It's a happy Wednesday. We're almost there. We will be back in a couple of weeks. So again, abetterlifetogether.org/event. If you want to see the event that is coming up next, I'll be updating that today. You have an amazing day too, Claudia. We'll see y'all in a couple weeks.
Excellent. Thank you so much, Melissa. Thank you, everybody.